Hey folks, this is Dennis Bourne, criminal defense attorney and former felony prosecutor. And as I've said many times before, I was assistant DA along with Mr. Farren here, who later got elected to the Randall County Criminal District Attorney Office, served as a criminal DA in Randall County for what, 6 terms, 24 years.
Yep.
You have what, near 30 or a little over 30 years prosecutorial experience? Something like that.
A little over 30 prosecuting, 7 years as a police officer, so 42 years in law enforcement related efforts.
So what I wanted James to go into today, and I'll let him kind of run with it, and I might interject occasionally, is just kind of the process so you can understand how a criminal case develops from investigation to the DA's office and how that can interplay with the defense attorney too along the way. So James, take it away.
Well, there's really a 3-step process for a felony case to arrive at the courtroom, and then there's a lot of subplots that play their way out during the process. First of all, the law enforcement authorities conduct their investigation, and that usually involves gathering physical evidence, statements, follow-up interviews, testing, labs sometimes involved, sometimes autopsies are involved. But at some point, law enforcement makes a decision as to whether they believe there's sufficient evidence to believe that a crime occurred and that a case needs to be filed. When they've reached that point, one way or another, they forward that information to the district attorney or county attorney if it's a misdemeanor, and the prosecutor's office becomes the gatekeeper. We review the file, we look at the evidence they've gathered. Sometimes we suggest to them, look, we think some more work needs to be done in this area. Sometimes we have our own investigators that do follow up. But after law enforcement makes their initial decision that there's enough there or not for a case, it's forwarded to us. We review that information, and if we decide there is sufficient evidence, then we file what's known as a complaint. A complaint is just a piece of paper that informs the person who's being accused what it is the state says they did wrong. The complaint, if the individual who's being accused hasn't yet been arrested, then law enforcement will take it to a judge, a magistrate, and ask that a warrant be issued. And so the complaint will include what's known as a probable cause paragraph. And it's a short summary of the evidence and why the state believes that a crime has occurred and this person's the one that committed it. If the judge decides that there is sufficient evidence, a warrant's issued if the individual hasn't already been arrested. Now,
let me jump in there. The probable cause paragraph, people get a little bit mixed up on that. It really doesn't have anything to do with the search necessarily, but probable cause is required as a safeguard to make sure that, so the prosecutors can't just go charging people willy-nilly, right?
Right. The same is true with a search warrant or an arrest warrant. The judge has to be convinced that there's sufficient probable cause to believe that either there's evidence where they want to search or that a crime has occurred and this person committed the crime in order to get, instead of a search warrant, an arrest warrant. It is not a lengthy, detailed explanation of the evidence. It's not a trial on paper. It's just a summary that it is hoped will convince the magistrate that it is probable that this individual is the one that committed the offense. From the time the complaint is filed until the case arrives in a courtroom, if that ever happens, is the grand jury. The grand jury is the final gatekeeper. They review our homework. They review the efforts of the law enforcement authorities and the work we've done on the case, and they are a safeguard between the prosecutor's office, law enforcement, and the citizens. As Dennis said a moment ago, the state can't just willy-nilly decide, well, I don't like Joe Blow, so I'll just charge him with theft, even though there's really no evidence he committed the theft.
Address this, James, and I've heard this, of course I've even said it, is that many times grand juries will, because they only hear from the prosecutor and the defense, they can hear from they want. But
True.
there's an old adage that if the DA brings a ham sandwich into the grand jury, they'll indict it.
There's an old cliche that says that the DA can get a ham sandwich indicted. But that's not true if the grand jury is being conducted correctly. If it's been conducted correctly, then the DA makes sure, the prosecutor makes sure that grand jury hears the full story, warts and all, everything, at least in summary, so that the grand jury can make an honest decision about whether or not this case should be indicted. And it's only with an indictment that a felony can be taken to trial in a district court.
And the grand jury is just deciding, one, is a crime committed, and two, did a given person or persons do it? More likely than not the high standard beyond reasonable doubt that a pettit or a trial jury would decide. And
as I've said many times to grand juries, your job is to decide, is there enough evidence that we want to send Farren into the courtroom and see if he can prove this beyond a reasonable doubt or not.
Okay, and I'll suggest one semi-gatekeeper, and that is defense counsel. I often defend prosecutors, having been one, and say to clients, look, the prosecutor only knows what they're told. And they're not themselves investigating anything. They don't have any direct knowledge. So sometimes we have information that can weigh on or change either a charging decision if it's early enough, or cause a result like a dismissal sometimes if facts basically undermine the case, right?
There's been many cases where the defense has convinced me or other prosecutors that you've got a problem with this case. I don't think the person did it, or I don't think you can prove it. And prosecutors welcome that information. I would much rather learn about it in preparation than with a big surprise once I'm in the courtroom. I don't want to waste my time. I don't want to waste the court's time, and I don't want to attempt to prosecute a person that it turns out didn't commit the offense. So if they have good information they're willing to share, we're always willing to listen.
Well, thank you, James. That's very helpful. We could go on and on about this, and there's just a lot of issues, but we'll cover some more in future interviews. I hope you folks are enjoying these interviews, and I'm going to have some of the law enforcement personnel as time goes by. And like I tell you always, if you're interacting with the police, turn on your smartphone, get a video, at least get an audio. That can often help you. I hope this was helpful.
You want the bad news?
Just a second. Okay.
My stopwatch